Welcome to Ask the Lawyer, International Edition, the radio show that brings you the latest trends in immigrating to the United States. Hosted by attorney Brian Figueroa of the law firm Figueroa and Associates. This program is designed to provide valuable insights for those who wish to live, work, study, or invest in the U.S. Whether you're an international student seeking educational opportunities, an entertainer looking to break into the U.S. market, or a business owner wanting to expand your operations and tap into the vast U.S. economy, this show is for you. If you're an investor exploring options in the U.S. or someone with family or friends already living here, you won't want to miss the important information shared on Ask the Lawyer, International Edition. Each week, we dive into critical topics that help you navigate the complexities of U.S. immigration and business law. Special guests include experts in business development, elected officials supportive of immigration, business owners, and nonprofit leaders who provide real-world advice and guidance for those wanting to build a future in the U.S. The law firm of Figueroa and Associates was founded not only to serve our clients, but to contribute to the greater good. We understand the importance of helping individuals and businesses achieve their American dreams, and we are committed to providing the legal expertise and support needed to make that happen. So whether you're an entrepreneur looking to open a branch of your business in the U.S., an investor ready to explore opportunities, or someone hoping to migrate and build a new life in America, you should tune in and learn from this informative program. Ask the Lawyer. International Edition is your resource for understanding U.S. immigration trends, business opportunities, and legal strategies. Call now. For personalized legal advice, contact the experienced attorneys at Figueroa and Associates today. Our team is here to help you navigate the path to success in the U.S. Thank you for listening to Ask the Lawyer, International Edition with attorney Brian Figueroa. Visit us online at askthelawyer.us or call today to schedule your consultation.
Is your spouse a green card holder or a U.S. citizen? The answer makes a big difference in how and when they can petition for you to come to the United States. If you are already here or you have children in the Caribbean or the U.S., you also need to think about estate planning. Unmarried partners and families deserve protection too. Don't leave your future at risk. Share this important information and call us right now, 855-768-8845, to learn how to protect yourself and your loved ones.
Green card holder petitioning for a spouse. File now or wait for citizenship. When a U.S. green card holder, lawful permanent resident, marries a spouse who is overseas, they face an important decision. Should they petition immediately for their spouse under their current status, or wait until they become a U.S. citizen to file the petition? The key consideration in this decision is speed, how quickly the spouse can reunite with them in the United States. This article provides a detailed analysis of both options, comparing the processing times, legal implications, risks, and strategic considerations to determine which route is the fastest. Understanding the immigration process for a spouse. A U.S. green card holder or citizen can sponsor a foreign spouse for a green card, allowing them to live and work in the United States. The process involves filing Form I-130, Petition for Alien Relative, with the U.S. Citizenship and Immigration Services, USCIS. For green card holders, the petition falls under the F2, a family preference category, spouses and minor children of lawful permanent residents. For U.S. citizens, the petition is categorized as an immediate relative petition, which does not have a visa backlog. Processing time varies depending on whether the petitioner is a green card holder or a U.S. citizen. The primary concern is whether filing immediately as a green card holder is faster than waiting to naturalize before filing the petition. Option 1. Petition immediately as a green card holder. A lawful permanent resident, LPR, can file Form I-130 immediately after marriage. This starts the immigration process for the foreign spouse under the F2A category. Advantages of filing immediately. 1. Establishes a priority date. The I-130 petition secures a place in line for visa availability based on the date it is filed. The earlier the petition is submitted, the sooner the spouse can immigrate when a visa becomes available. 2. Reduces future delays. If the petitioner delays filing and the spouse's country has a long wait time, the process can be significantly prolonged. By securing a spot in the queue, they can minimize unnecessary delays. 3. Potential for automatic upgrade. If the petitioner becomes a U.S. citizen while the I-130 petition is pending, the case automatically upgrades from the F2 a category to immediate relative status, eliminating the visa backlog. This can shorten the processing time considerably. Disadvantages of filing as a green card holder. 1. Visa bulletin wait time. Unlike spouses of U.S. citizens, spouses of green card holders face waiting periods due to annual visa limits in the F2 a category. Visa bulletin updates determine how long it takes for an F2 a visa to become available. 2. Longer consular processing. After I-130 approval, the spouse must wait for a visa number before proceeding with consular processing or applying for an immigrant visa. This can take months or even years, depending on visa availability. 3. Spouse cannot enter the U.S. on a tourist visa to stay. If a green card holder petitions for their spouse, the spouse cannot legally enter the U.S. on a tourist visa with the intent to remain permanently. If discovered, it can result in visa denial or inadmissibility issues. Option 2. Wait to become a U.S. citizen before filing. If the green card holder is eligible for U.S. citizenship soon, they may consider waiting until they naturalize before submitting the I-130 petition. Advantages of waiting for citizenship. 1. Immediate relative category, no waiting for a visa. Unlike the F2 a category, spouses of U.S. citizens fall under the immediate relative category, which is not subject to visa backlogs. This significantly reduces the overall processing time. 2. Faster processing overall. The I-130 petition and green card processing for immediate relatives typically take 12 to 18 months, much faster than F2A processing with visa backlog delays. Consular processing is also faster for immediate relatives. 3. Spouse can enter the U.S. on a K3 visa. A U.S. citizen can file for a K3 visa, allowing their spouse to enter the U.S. and wait for green card approval inside the country. This option is not available for green card holders. 4. More flexibility with adjusting status. If the spouse is already in the U.S. on a valid visa, such as a student or work visa, they can adjust status to a green card without leaving the country. This option is easier for spouses of U.S. citizens than for those of green card holders. Disadvantages of waiting for citizenship. 1. Delaying the start of the immigration process. If the green card holder has several years before they are eligible to naturalize, waiting to file can delay the process significantly. In contrast, filing immediately secures a place in line for the spouse's immigration process. 2. Uncertain naturalization timeline. Naturalization can take 1 to 2 years, depending on USCIS processing times and the petitioner's eligibility. If there are delays in citizenship approval, waiting to file could slow down the spouse's immigration process even further. Which option is faster? The fastest option depends on the petitioner's eligibility for U.S. citizenship and current visa wait times in the F2A category. If the green card holder is eligible for U.S. citizenship within 1 year, waiting to naturalize before filing is likely faster. If citizenship is 2+ years away, filing as a green card holder is advisable to establish a priority date and avoid unnecessary delays. If the petitioner is uncertain about their naturalization timeline, filing immediately provides a backup option that can later be upgraded. Estimated timelines comparison. Option timeframe. File as a green card holder, F2A, 2 to 4 years, depending on visa availability. Wait to become a U.S. citizen, then file 12 to 18 months after naturalization. File now as an LPR and upgrade upon naturalization can speed up processing if citizenship is obtained quickly. Final recommendation: file now or wait. For most green card holders, the safest strategy is to file the I-130 immediately and then upgrade the petition upon becoming a U.S. citizen. This ensures that the process has started while also allowing flexibility if naturalization occurs sooner than expected. However, if the petitioner expects to become a U.S. citizen within 1 year or less, it might be worth waiting to file under the immediate relative category, as this significantly shortens the waiting period. Each case is unique, and factors like country-specific visa wait times, the spouse's travel needs, and potential obstacles to naturalization should be considered when making a final decision. Consulting an immigration attorney can also help ensure the best course of action for reuniting as quickly as possible.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, ask the lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
Hello, people out there. I'm Julian from St. Lucia, and I'm here in Mr. Figueroa's office. Mr. Figueroa represented me for past, 10 years. I was going through some removal proceeding, and I go to several lawyers. Some of them asked me to run away. Some of them said they cannot do anything for me. And my Consulate General, Jeremiah Hyacinth, he recommended me to Mr. Figueroa. And right now, I go through a lot with Mr. Figueroa. Mr. Figueroa is the only one that stands with me. And right now, I believe I'm the happiest man in this world right now with a 10-year green card. 10 year, and in the next 2.5 years, I'll be filing for my citizenship. And that's me, happiest man today. Thank you.
Are you an artist, band, or musician looking to perform in the United States but need help navigating the complex visa process? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to assist. Our experienced immigration attorneys specialize in entertainer visas, including P1, P2, and P3 visas. We'll guide you through every step, from securing a U.S. sponsor to filing the necessary petitions and preparing for your consular interview. With our legal expertise, we'll ensure that your visa application process is smooth and stress-free so you can focus on what you do best, performing. Schedule a consultation today at visiting www.askthelawyer.us or call 855-768-8845. Figueroa and Associates, your trusted partner in U.S. immigration law for entertainers.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For a consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa and Associates, and your presenter with a special immigration report. Denaturalization and the administration's targeting of U.S. citizens. In July 2025, the Department of Justice, DOJ, elevated denaturalization to a top enforcement priority, marking a dramatic shift in how the federal government approaches U.S. citizenship. While the Immigration and Nationality Act, INA, has long authorized revocation of naturalization, historically such cases were rare and confined to extraordinary circumstances, such as involvement in genocide or espionage. From 1990 to 2017, only 305 cases were pursued, an average of 11 per year. Under the first Trump administration, however, referrals for denaturalization rose by 600%. Expanding the grounds for denaturalization. The June 2025 DOJ memorandum identifies sweeping categories of people who may be targeted. These include anyone the DOJ deems sufficiently important, individuals accused of being potential dangers to national security, or even citizens referred in connection with pending criminal charges. Yet the INA itself provides only limited basis for revocation, fraud or misrepresentation in the naturalization process, affiliation with subversive organizations within 5 years of naturalization, conviction for naturalization fraud, dishonorable discharge from the military, or refusal to testify in specific congressional proceedings. By extending beyond statutory limits, the DOJ risks wasting resources on cases that cannot withstand judicial scrutiny, or worse, attempting to rewrite the law by practice. The 14th Amendment guarantees that citizenship cannot be taken away without due process, and courts have consistently required a high burden of proof. Clear, unequivocal, and convincing evidence in civil cases and proof beyond a reasonable doubt in criminal cases. Civil liberties at risk. Despite these constitutional safeguards, the DOJ's policy carries grave risks. Because denaturalization cases are typically civil, there is no guaranteed right to legal counsel, and many individuals may never be aware that proceedings have been filed against them. Once citizenship is stripped, a person can be rendered stateless, losing access to fundamental rights and daily necessities, such as employment, housing, and identification. Alarmingly, vague terminology like sufficiently important or potential national security threat grants the government broad discretion that can easily be abused. The American Constitution Society has already warned that past litigation practices risked mistakenly revoking citizenship from individuals who committed neither crime nor fraud. Threats to democracy. History provides chilling lessons. Stripping citizenship was weaponized by authoritarian regimes, including Nazi Germany, and during America's own McCarthy era. The Supreme Court has long cautioned against allowing citizenship status to rest upon the political temper of majority thought and the stresses of the times. Schneiderman v. United States, 1943. If left unchecked, the DOJ's denaturalization campaign could undermine confidence in the permanence of naturalization, discourage immigrants from pursuing citizenship, and erode civic participation. Over time, such policies risk weakening not only the rights of individuals, but the very democratic institutions they are meant to protect.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa and Associates. For consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Do you have a family member overseas that you want to bring to the United States? The law firm of Figueroa and Associates, located in Brooklyn, New York, is here to help. Our experienced immigration attorneys specialize in family-based green card petitions, guiding you step by step through the process to reunite you with your loved ones. Whether you're a U.S. citizen or a green card holder, we will ensure your petition is handled smoothly and efficiently. Plus, we can help you understand how filing for a green card may impact your relative's visitor visa. Schedule a consultation today. Visit askthelawyer.us or call 855-768-8845 to discuss your case with our skilled legal team. Figueroa and Associates, your trusted partner in family immigration law.
Hi, my name is Brian Anthony Figueroa, and you are listening to Ask the Lawyer with my father, Brian Figueroa.
Estate planning for unmarried partners. Protecting your loved one's future. Estate planning is often thought of as something married couples do to protect each other and their families. But what if you're in a committed relationship without a marriage certificate, civil union, or domestic partnership? For unmarried partners, estate planning isn't just important, it's absolutely essential. Without the right documents in place, your partner could be legally excluded from inheriting your property or even making decisions about your health care. State laws do not automatically protect unmarried couples, which means if one partner dies or becomes incapacitated, the other may be left with no rights at all. Why estate planning is crucial for unmarried partners. If you are not legally married or in a recognized partnership, the law does not view your relationship the same way it views a spouse. This can have devastating consequences if something happens to you. 1. Inheritance rights. If you die without a will, your estate is distributed under New York State intestacy laws. These laws prioritize spouses, children, and blood relatives. Unmarried partners are not recognized, which means your partner will inherit nothing, no matter how long you've lived together or shared assets. 2. Healthcare decisions. Without proper planning, your partner may not be able to make medical decisions for you if you are incapacitated. Hospitals will defer to your legal family, parents, siblings, or children. A healthcare proxy or power of attorney is essential to ensure your partner has a voice. 3. Property ownership. If only one partner's name is on the deed or lease, the other could lose their home upon death. Estate planning tools like joint tenancy, living trusts, or transfer on death deeds can prevent this. 4. Financial security, bank accounts, retirement funds, and life insurance policies may not automatically pass to your partner unless you specifically designate them as a beneficiary. Estate planning ensures financial protection. 5. Guardianship of children. For unmarried couples raising children, guardianship can become complicated. Without clear legal instructions, the surviving partner may not automatically retain custody. Estate planning clarifies and secures guardianship rights. In short, estate planning ensures your partner isn't left out in the cold simply because the law doesn't recognize your relationship. Essential estate planning tools for unmarried couples. A skilled attorney can help unmarried partners use estate planning tools that provide the same protections married couples enjoy. These include wills. Clearly state who inherits your property, ensuring your partner is included. Living trusts. Allow your partner to manage or inherit assets without probate. Durable power of attorney. Authorize your partner to handle financial and legal matters if you cannot. Healthcare proxy and living will. Ensure your partner can make medical decisions and that your wishes are respected. Beneficiary designations. Update retirement accounts, insurance policies, and bank accounts to name your partner. Joint ownership of property. Establish joint tenancy with rights of survivorship to protect shared homes. Guardianship nominations. Secure custody rights for children in blended families. These tools, when properly drafted and executed, give unmarried couples the legal recognition and protection that state law does not provide automatically. Why you need an estate planning attorney. While DIY estate planning kits are widely available, they often fail to address the complex realities unmarried partners face. Small mistakes, like failing to update beneficiary designations or mismanaging trust documents, can cause your partner to lose everything you intended for them. An experienced estate planning attorney ensures your documents comply with New York law. Your partner is fully protected, both financially and medically. Tax strategies are used to minimize estate taxes and maximize inheritances. Potential disputes with family members are prevented through clear, enforceable instructions. Complex issues like blended families, business ownership, or real estate are properly managed. Estate planning for unmarried partners requires customized solutions. An attorney provides the tailored guidance you need to avoid costly mistakes. Why choose the estate planning law firm of Fidrux & Associates in Brooklyn, Figueroa and Associates is the trusted choice for estate planning, especially for unmarried partners seeking peace of mind. Here's why. 1. Experience in New York estate law. The attorneys at Figueroa and Associates have years of experience navigating the nuances of New York estate planning, probate, and family law. They know how to protect unmarried partners from being excluded by default inheritance laws. 2. Comprehensive services. The firm offers everything from wills and trusts to healthcare directives, guardianship planning, and probate services. This full-service approach ensures every aspect of your estate plan is covered. 3. Client-centered approach. Every relationship is unique. The attorneys take time to understand your goals and design an estate plan tailored to your life, your assets, and your partner's needs. 4. Conflict prevention. Unmarried partners often face challenges from family members who may contest wills or challenge inheritances. The firm drafts documents with clarity and precision to minimize disputes. 5. Accessible and trusted. Located conveniently at 26 Court Street, Suite 701, downtown Brooklyn, Figueroa and Associates is a cornerstone of the Brooklyn legal community. Our website, AskTheLawyer.us, and phone number 855-768-8845 provide easy access for consultations and resources. X. Compassion and discretion. Estate planning involves personal and sometimes sensitive issues. The firm handles every case with compassion, discretion, and respect for your privacy. The cost of doing nothing. If you don't have an estate plan and you're in an unmarried partnership, the consequences can be devastating. Your partner inherits nothing. Your partner cannot make medical or financial decisions for you. Your children may be placed with other relatives. Family disputes may erupt, leaving your partner without legal standing. Your wishes may never be carried out. The good news is that with the right attorney, these outcomes are preventable. Conclusion. For unmarried partners, estate planning is not optional. It's essential. Without it, the law offers no protection, and your partner could be excluded from your estate, medical decisions, and even the home you built together. The best way to safeguard your relationship, your assets, and your loved ones is by working with an experienced estate planning attorney. In Brooklyn, the right choice is the estate planning law firm Figueroa and Associates, located at 26 Court Street, Suite 701, downtown Brooklyn. Visit AskTheLawyer.us or call 855-768-8845 to get started today. Your legacy, your wishes, and your partner's future deserve the protection only a well-crafted estate plan can provide.
Do you have a legal issue, question, or concern? Turn to Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us. You can also register for our paralegal program, get legal news, business consults, or other information on educational issues. Yes, Ask the Lawyer. You have questions? We've got answers. For a consultation or to refer a client, visit www.askthelawyer.us. Again, www.askthelawyer.us.
This show is a production of IQ Inc. Marketing. If you would like to advertise your product or service on this show to the U.S. and Caribbean markets and through our multicultural publications in New York, please call 866-435-3286 or send an email to info@myiqinc.com.
Thank you for listening to Ask the Lawyer International Edition with attorney Brian Figueroa of the law firm Figueroa and Associates in New York. We hope you enjoyed the show, which featured immigration visitors visa, starting and doing business in New York, entertainment and business visas, religious visas, and much more. Whether you are outside the U.S. or have family in New York, the number to call, share, and keep is 855-768-8845. That's 855-768-8845. Please schedule a consultation with us at www.askthelawyer.us. That's www.askthelawyer.us. This is Ask the Lawyer, International Edition. You have questions? We've got the answers.